Okay, so if you want to start with introducing yourself, and just kind of we can start with some of the questions that people may have, or you can just cover some of the essentials of intellectual property and kind of how do you protect your what you're creating.
Yeah, that sounds like a good plan. I'll do a quick introduction on myself, and I'd love to, learn more about the people that are on the call as well. So if you guys don't mind introducing yourselves, that would be very helpful to me as well. I am Samar Shah. I'm a patent attorney. I primarily work with, kind of high-tech clients who are, developing technology innovations, and I help them protected by writing and filing patent applications on those technologies. My background, before I was an attorney a long time ago, I used to be an engineer. I was a biomedical flight controller. And I used to work at NASA in Houston in Mission Control Center. And I used to monitor some of the bio equipment on the space station. So that was my background. I went to school at Vanderbilt University, and then I went to law school out in Silicon Valley in California, and then I practiced law at a law firm there for almost eight years or so, and I represented companies like Facebook and Google and Twitter and GoPro on a lot of their patent filings. That's my background. My wife and I, we moved here to San Antonio a couple of years ago, and I started this law firm, it's been fantastic in terms of representing the tech community here in San Antonio, but also just kind of getting to know the broader small business community. It's been really fun. One of the I always get asked this question as to why are you doing this, and my answer is always this, that you know my dad and I moved here to the United States, immigrated from another country, and my dad wanted to start a business, and we didn't have any skills or even language skills or business skills to be able to do that. But we went to a lot of sessions like these ourselves at the library, and people just helped us out of the goodness of their heart, um, and it made a huge difference in terms of his life and our life and my future. So it's been a real blessing, and I always thought that, hey, if I was ever in a position to kind of give back and help others, I would do so. And this is part of it, is just being able to help other people, getting them started. A lot of times the questions that small business owners have, um, you know I can answer them in a few minutes, and you know it would prevent or help them from having to think about lawyer fees and legal fees and finding an attorney and all that stuff. And I'm happy to answer those questions. And also, I've found that legal tends to be a mental hurdle for a lot of small business owners, where they're just paralyzed by what is my risk here, what is my liability. So being able to answer some of those questions, and without having worry about all that stuff and overcoming those mental roadblocks, is a big part of what I do. So that's a little bit about me. I do this, like I said, to help other people, so we don't expect anything in return. But I do ask that if you found this useful or not useful, that you leave us some feedback, and that would be super helpful and valuable to us, so that we can keep tweaking the program and improving it and making it um, a right fit for the people who attend. So I'll stop talking there, and I'd love to hear more about you guys, and what kind of questions you have, so we can tailor this to your questions specifically. So Daniela, I think we can just go in order here. Um,
You need me to
or do
start?
you want? Yeah, why don't you?
I can start to break the ice. So my name is Daniela. I work with Launch SA. As I mentioned before, I've been with Launch SA for 2 years. And my role at Launch SA is the actual role is called Impact and Development Manager. But what we do is kind of gauge that impact and develop programming that helps entrepreneurs. And that means kind of fostering relations with mentors, like the one we do with mentor rounds, or just for you to tell us what you need and go and seek those resources and kind of report back to what impact we're having in the small business community. So that's me. I don't know who else wants to go next. I'll call someone out if nobody. Oh, there you go, Jenna.
I can go. Okay. I'm Jenna. I'm interning with Launch SA this summer. So I'm from California and I go to Middlebury College, where I study economics and studio art. But yeah, I'd just love to hear. And Daniela's having us just like sit in on this call and get to learn more about intellectual property. Yeah, can't wait to listen. So thank you so much.
I'm Taylor. I'm also interning with Launch SA, and my job is kind of the content creation person, so I'm kind of running the social media and helping out with that stuff. But I go to UTSA, the University of Texas at San Antonio. I study Russian, global affairs, and linguistics, and I'm actually interested in going into law school potentially, so I'm really excited to hear more about IP law.
Very cool. Well, it's nice to meet you guys. I think those are all the interns on the call. Is that right?
I'm also an intern on the call.
Okay, great.
So my name is Jake. I go to Trinity. I'm studying poli-sci and economics, and like Taylor, I'm also interested in law school. So this is particularly an interesting session for me, even though I'm not interested, even though I don't know much about like patents and intellectual property. So it'll be good to learn more about that.
Very cool. So nice to meet you guys. Thanks for joining the call. I hope this is interesting for you guys. And then also, would love to, answer your questions about IP law and the legal world. So this is just as much for you guys as for others on the call. So thank you guys for joining.
Hello, I'm Valerie Kutlu. I'm an entrepreneur and I'm, kind of testing the waters to see about patenting a product and bringing it to market.
Okay, very cool. Well, nice to meet you, Valerie. And, what kind of questions do you have?
So I guess one of my questions is, it's a apparel product, and I want to, I'm just kind of wary of showing it to manufacturers so that way they can work with me, so they can help me like fine tune the product. And so far I've just been using an NDA, but I wonder if that's okay, or am I, I wasn't sure, like, do I get this patent now? I feel like I'm not at the final design yet. And what about if I have to add to it or tweak it? So that's kind of where I am at.
Gotcha. Yeah, those are all good questions, and we'll cover them as we go. Do we have one more person on the call?
Stacy, Hill Delights. I don't know if you have like a question you want to cover, or just like a brief overview of why you're joining the intellectual property session. Maybe you're muted. I don't know if that helps to know.
Yeah, and Daisy, if you can hear us, we're just kind of going around introducing ourselves. So if you're able to introduce yourself, we'd love to learn more about you and see if we can answer questions that you have specifically. Oh, looks like she might have left.
Oh, there's a phone joining. Maybe that's her.
Are you looking for Rachel, Daisy Hill Delay?
Hello, welcome.
Hi, sorry, I'm having computer trouble.
No worries.
It's okay. We all been there this quarantine. So if you, I we're just going around introducing ourselves, and Samar just wants to get a perspective about what you're in the call. Like if you have any specific questions, that way he's able to cover those as he goes and talks about intellectual property.
Well, for me, it's the curiosity on being able to, I guess, copyright or patent or whatever I would need to do more of a business model. I do custom cakes and cookies, and I do different, like, really interesting cookie flavors. And I have a model kind of like marble slab. You know how they get to, pick your ice cream, pick your mix-in, pick whatever. I want to do something like that, but with cookies, because the recipe I have bakes in like 7 minutes. So kind of like fast food cookies, but bake your own, do that. And it's not something I'm doing currently. It's not something I've launched, just an idea I have. And before I kind of get the ball rolling on that, I wanted to see if it was something I could protect, because I think it's a great idea, but I don't have as much financial backing. And I wouldn't want the idea to catch on and somebody with more money to kind of blow up with it.
Yeah, those are all great questions. And I think some things that every small business and early stage business an entrepreneur worries about, I think. So I think this is great. And I think we should be able to answer some of those questions for you here. Why don't we do this? I'll go through kind of a quick overview of intellectual property law so that you guys kind of get familiar with it, with the different aspects of it. And then we'll, jump into specific questions that you have so that we can start answering them and making this thing useful for you guys. But I think just having an overview is going to be helpful to you guys. As you move forward and as your business needs develop, excuse me, and change over time, you'll be able to hopefully quickly figure out when you need to start thinking about talking to an attorney or getting some additional help as you go. So, with that said, here's a kind of a quick overview of IP law. So as you guys know, IP laws are laws that protect intellectual property. So as opposed to the physical or tangible property that is in your business, intellectual property protects what's in your brain, right? Or in your employees' brains or in your company's collective brains. Usually there are 4 primary buckets of intellectual property laws that protect companies and inventors and innovators. The first is patents. And patents protect anything mechanical or software or any apparatus that you can think of. Patents are also useful for protecting designs, for example. Some apparel products fall into that category. And then there is copyrights. Copyrights protect a written work of art or any work of art that has been affixed to a tangible medium. So those things include, for example, written works like novels and books and papers that you've written. It would protect photographs and sculptures and things like that. And then there's trademarks. Trademarks protect your brand name. So think of Nike, for example, and the swoosh, or the Coca-Cola brand or the Apple brand. Those brand names are protected by trademarks. And with a trademark, you can protect the name as well as your slogan and the design logo of your company. So that's what trademarks are used for. And then there's trade secrets. The trade secrets are things that are really difficult to protect via the other mechanisms, but nonetheless ought to be secret to the company. So the KFC recipe, for example, or the Coca-Cola recipe, for example, would be things that are a trade secret. So they're proprietary to the company, and should not be disclosed to the public without specific permissions. Trade secrets can literally protect anything that you can think of that you can keep secret, right? Keep under some kind of a lock and key. And it could include customer lists, it could include recipes, it could include procedures for doing things. It could be anything really. So those are the 4 primary categories of intellectual property. And then if you can't protect yourself with any of these 4 categories, the way that we help our clients protect things is via contracts. So, you can have a contract like a confidentiality agreement with another party that preserves your either trade secrets or just proprietary information that's yours. You can have an assignment agreement where you can work with somebody and they would give up any intellectual property rights that they have to that work over to you. And then there's some other ones that kind of come into play as well. But those are the 5 main ways you can protect the intellectual property that is within the company. Does that make sense to you guys?
Yes, I guess
Yeah.
like it doesn't all fall under the same thing. It depends on what you want to do in the industry and everything. Where should you kind of spend your money protecting your products and everything?
Yeah, so Daniela, you bring up a good question. So these are the 4 ways that is theoretically possible for you to protect your invention, and I think you should be thinking about all these things. But the second, and just this interesting question, I think, especially for early stage businesses, is figuring out what is the best way for me to protect my invention, right? Or my innovation that is happening at the company. Because oftentimes, whatever you're working on is going to fall into multiple of these categories, right? So you have a business, you may have a product that you may want to protect via patents, you may have a company name that you may want to protect via a trademark, you may have a recipe that you may want to protect via trade secret. But which one do you do first, right? I mean, for big companies, they would do them all because they have the budget for it. But that may not be the case for you. So, we have to spend some time thinking about, what is the most important part of the IP here that's worth protecting and spending money on, and which ones of these things can wait into the future as you grow the business and have some revenue coming in. And my answer to that is always, what is the one thing in your business or 2 things in your business that is, making your customers come to you as opposed to go to your, competitor down the street? What is the one thing that brings them to your doors? And I would protect that thing first, right? So if it's the name of the company that's bringing people over because of your reputation in the community, then maybe trademarks are the way to go. If it's because of the product itself that's not being offered anywhere else, then maybe the patent is the way to go. If it's the service and the contacts that you provide people, maybe a trade secret is the way to go. But you really have to spend some time thinking about what is your secret sauce, or what is the thing that's driving business for you as opposed to other things. So to give you some context, let's say you were advising Coca-Cola, for example, right? And Coca-Cola didn't exist prior to today, and the founder comes to you and says, "Hey, I have this awesome new soda thing. It's going to be a huge hit, and I want to start, protecting my intellectual property." What would you guys tell the Coca-Cola founder based on what you guys know today? And feel free to jump in, anyone.
I would say the recipe.
The recipe, the
So a
Coke
trade
recipe.
secret?
Okay. All right. So Daniela, you're up first. Why the recipe?
I mean, assuming that there's no product like Coca-Cola today, I think that's what's most important. I mean, I don't know.
Yeah. Very good. I think we had Taylor and Valerie jumping in as well.
Oh yeah, I was just saying trade secret because it would be the recipe itself, correct? Is
Mm-hmm.
that what a trade secret is? Okay.
Yeah. Okay. Valerie.
Yeah, I was gonna say the trade secret too, because if they patent it, then it would expire and people could make it.
Yeah. Yeah, very good. I think you guys are, on the right track. I sometimes think about what I would tell Coca-Cola if they came in to my office, right? Or a company like Coca-Cola that's just starting out. Um, and it to me, it's a tough one, right? The recipe certainly seems like the most important part, but if you do these like blind taste tests or random taste tests amongst people, most people can't tell the difference between a Coke recipe and a RC Cola recipe and a Pepsi recipe, right? Like, statistically, people can't tell the difference between, the Coke soda and some of the other sodas. Um, so if you had that piece of data, then what would you tell Coca-Cola?
Probably trademark.
Trademark. Why trademark?
Well, if they can't tell the difference in the recipe, then you kind of are like, for me that I bake, like you kind of already have that. If people have a general idea of what's in there, they just don't know exactly. So it's somewhat protected. But if they're unable to recognize between different brands, then you want to kind of establish your brand so that you can make that recognizable, and they make it more of, they're like, oh, that one is Coke.
Yeah. Yeah. That's a great thought. Do we have any others?
Maybe like a patent on the packaging of Coca-Cola. So like the glass bottle or whatever, it's very unique. So I don't know if that's possible to patent, but like making it look different and patenting however it looks.
Yeah. Also a very interesting thought. You know, in fact, um, that bottle, the shape of that bottle, falls under what's called a design patent. So a design patent protects the way something looks. And the shape of that Coke bottle is maybe one of the most famous design patents that exist out there. But they were able to protect the shape of that bottle and really leverage that kind of form factor and feel to drive more soda sales. So, that's something you could do. The other famous design patent is the shape of the iPhone, for example, right? In fact, Apple sued Samsung for infringing their design patent for creating a product that looks similar to the iPhone. And the jury agreed with Apple and awarded them $1 billion in damages. So Samsung had to fork over $1 billion for infringing that design patent. So design patents can be very powerful, and if that's the thing that's driving sales for you, it's very important. And then I forgot who said trademark. I think it was Jenna or Valerie, um, but that's a very important piece of this too, right? If you let's see, oh, maybe it was somebody else. But yeah, if you have, if Pepsi existed, for example, and RC Cola existed, and then you had a new company, called Coca-Cola that's trying to sell a soda that's pretty similar to these other sodas, but they think it's better. But if you put a blindfold on people and ask them to, differentiate between these and pick which one they like more, they wouldn't be able to give you a good answer. Would it be worth protecting the recipe a whole lot at that point? Or are people buying Coca-Cola products because of kind of the brand that's associated with that company? Um, you know, so I would spend a lot of time thinking about why people are buying your stuff. I personally think that, Coca-Cola and Nike are two of the biggest or the best marketing companies in the world, and they just happen to sell soda and shoes, right? But if they could potentially sell anything, and they would probably do well because of the way that they've branded their products. I mean, if you buy shoes and you buy Nike shoes versus some other shoes, and put a blindfold on and told you to walk around on those shoes, you probably would not be able to tell the difference between a Nike shoe and a non-Nike shoe, right? But it's that kind of brand awareness and the brand trust that is associated with these shoes that make you purchase these over something else, or at least allow Nike to charge, maybe 10 times as much as you would pay for a non-branded shoe of the same design and style. So in those cases, it's the brand that's driving all the sales. And at that point, I would protect the trademark, right? And protect the brand and not so much the recipe. So you really have to figure out what is driving sales for you. And it's not always an easy thing to do, because as the entrepreneur, you're in the weeds, right? You are making this product. You think it's differentiated. If you talk to the Coca-Cola founder and ask them, why are people buying your stuff? I am fairly certain he or she would have said it's because of the way the thing tastes, not because of the marketing that's behind it, right? It's hard thing to figure out when you're the entrepreneur, but it's worth doing, because you don't want to spend your money on legal fees protecting something that's not making a difference for your business. Does that kind of make sense to you guys?
Yes.
Yes.
Okay, good. All right, so I hope that was helpful. Why don't we just jump into questions that you guys have now, and we'll go from there. And feel free to jump in, anyone.
So I have a question. If I'm looking to get the product manufactured in Turkey, would it make sense to get the patent in Turkey first?
Very, very good question. Yeah, so we'll take a step back. Patents are jurisdictional rights, right? So you can get an American patent, you can get a Turkish patent, you can get a Chinese patent. You can't. There's no such thing as a international patent. Now, there's some applications that allow you to get international rights through what is called a patent cooperation treaty, a PCT application. So that's entirely possible here. But, this is something that you should be thinking about in the first place. Generally, I would start with, where are going to be the bulk of your sales, right? Because that's the place where you want to prevent infringement. So if the bulk of your sales are going to happen in Turkey, then I would protect that, file the patent in Turkey. But if the bulk of your sales are going to happen in the United States, then the US is the best first place for you to file a patent on. So I would think about it from a sales perspective and not a manufacturing perspective, because even if they knock you off in Turkey and they sell 100 t-shirts in Turkey, you're not going to recoup a lot of money from them, right? Because the sales volume is not that high. Plus, the legal system and the court systems in a lot of foreign countries are suspect, right? Here we have a really great rule of law and a tradition of respecting people's intellectual property. They don't have that here, or they don't have that in other countries. So I had a client who, was having some of their materials manufactured in China, and they actually had set up a plant and a warehouse in China, and the company that they were contracting with ended up taking a bunch of their stuff, and they just started selling it as their own product in China. And luckily, my client had a patent in China, so we were able to go to the Chinese court and ask the Chinese judge to shut this infringement down. And it took, like 3 years to process that through the courts in the Chinese courts. And then by the time we got a judgment from a Chinese judge, the defendant had just disappeared. We couldn't enforce the judgment. Like, we had $1 million judgment that we were sitting on, and we couldn't enforce that, on anyone, because the principals had just disappeared. And then, a couple of years later, those principals reappeared in Canada, and they were selling our clients' products in Canada. So we went to a Canadian judge, and we said, look, we have this order from a Chinese judge. will you enforce that here in Canada? And, the Canadian judge has no obligation to enforce Chinese judgments, right? And they were like, we don't even know what the laws were. We don't even know if this judgment is appropriate or right. We can't enforce this. Thankfully, our client had a Canadian patent as well, so we asked them to enforce the Canadian patent, and the judge did so. And that took a couple of years as well. And by the time we got that judgment, the defendant disappeared again. So it's not an easy task for you to enforce your patents, all over the world. And it gets very expensive because you need to have, for example, Chinese lawyers involved and Turkish lawyers involved and Canadian lawyers involved. So think about where you need to enforce this as you make those decisions as well. If the bulk of your sales are going to happen in the United States, then I think a US patent is appropriate. In fact, most of my clients will file in the US because US tends to be the largest market for most of my clients. That's where most of the sales volume come from. And with the US patent, even if somebody makes it somewhere else and imports it here into the United States, we still can stop them with a US patent. So that's what I would think about. Does that make sense?
Yes.
Okay. All right, other questions?
I have a question. So how soon in the journey of an entrepreneur do you suggest looking at this, or are there certain industries that is kind of more important that you do it soon after than later, like soon before after than later, or like what do you suggest?
Great question. So it really depends on what the product is and what the competitive landscape looks like. Especially if you're going to be filing patents. Patents are first come, first serve, right? So whoever files the patent first gets earliest priority rights to that technology. So that's what I would think about here is what kind of IP rights do you need to enforce, and then who is going to be infringing those IP rights? What are some of your competitors doing? If your competitors are filing patents left and right, then maybe you need to do so as well. Or if they're suing each other on patent lawsuits left and right, then you need to protect yourself with patents as well. But if nobody's really doing a whole lot in your space as far as filing patents, then maybe you can wait. But with patents, it's first come, first serve. So keep that in mind. With trademarks, you can backdate your trademark, so you don't have to file it right away. But when you do file, you can show evidence to the trademark office saying that, hey, I actually started this thing a year ago or a year and a half ago. Can you give me priority all the way back to when I started the business? And if nobody has filed a trademark in the interim or started a similar business in the interim, then the trademark office is usually happy to allow you to get that date back. So with trademarks, it's a lot more about first to do business, as opposed to first to file. So speed is less important from trademark perspectives. With copyrights, copyrights start existing the day you put something down on paper or a tangible medium. So copyrights start as soon as you put pen to paper, or as soon as you take that picture, things like that. So time is less important from a copyright perspective, so you can wait there as well. But generally, the earlier that you file, the earlier you start having enforceable rights on your intellectual property. So if anybody violates those rights or steals your intellectual property, you have a mechanism for clawing that back or doing something with it. Without patent or IP protection, you're exposed on some level, and you may not be able to get that competitor out of the marketplace, or get somebody to just straight up copying your product and putting it out in the marketplace. So that would be my recommendation. But you also have to weigh that against, are you better off spending that money on legal fees, or are you better off spending that money on the product itself, right? And getting it manufactured, getting it out in the marketplace, doing marketing around it. So I would encourage you to think about that. What is more important to you? Is it to to start generating some revenue, knowing that, hey, I have some exposure here, or is it better for you to lock this IP down, and then even if it means that you're going to generate revenue a little later in the process? Those are things that I would think about. For my medical device clients, for example, it takes over $1 million in R&D costs to develop a medical product. Usually we file as early as possible, right? Because otherwise you've spent $1 million for nothing if somebody undercut you and filed a patent before you did. But for less R&D expensive clients, some of them will take the risk of launching something and then patenting it if the product is successful. And others of my clients are more risk averse, and they would much rather protect it before they move forward. So you really got to figure out where you feel comfortable, and how important is IP for you relative to the business progress that you would make with that same money.
Yes, that makes a lot of sense. And kind of in that same area, have you seen, like, is it like when you're dealing with investors or other people like coming into the business, is that a part that is important for them to know that you're in the process, or you already have some of the protections on the product and or other stuff, trademarks, patents? Have you seen, or have you had any experience with that is an issue, or that's kind of
Yeah,
important to have?
for
Like when
investors,
you're
is that
bringing
what
it,
you're talking?
yeah, or when you're pitching to get funding, or even, I don't know if the banks care at all about that, or any
Yeah.
other like external kind of influences that will influence you not having that protected?
Yeah, that's a very good question, and it varies depending on the stage that you're in. If you're getting a bank loan, the bank is probably not going to care a whole lot. They care about all these other metrics like your business plan and stuff like that. So for your first loan, you know, AP doesn't matter a whole lot. The business plan matters a lot more from a bank's perspective. If you have patentable technology, some early stage investors really do care about patents. And, I've known some investors who won't even, um, you know, invest in a company unless there is some kind of a patent pending status happening already. So some investors really, really care about patents, if your invention is eligible for one. And then there are other investors who just don't care at all, and they couldn't care less if the underlying technology has been patented or not. They just think that being first to market and speed to market is the most important metric for the company before they invest. So, try to figure out what your investors care about and then try to optimize for that, right? There's no one answer for everyone here. So, learn as much about your investors as possible. And if they care about patents, then I think it's helpful to have them. If they don't care about patents, then, I think you can save that cost for further down the line.
Right. I don't know if anybody else has any questions that they want to get in. If not, I'll have more.
I guess I have another question. So, like for the meeting with you or another patent attorney, what should we bring to the table already? Like what would we need to bring to the meeting to get started on creating a patent and things like that?
Yeah. Yeah, every patent attorney is a little bit different in terms of what they require. But I'll just tell you, what we like to see when we see clients. And, if you have any schematics or sketches of your product, that is very helpful. If you have any, process diagrams or system diagrams, that's very helpful. If you have a software-based invention, if you have anything written up about the benefits of the product, or the drawbacks of the products that exist in the marketplace today, that type of information is super helpful as well. But really that's all we need. And usually when we meet with clients, we're pretty good at being able to extract what the underlying technology is just by having a conversation back and forth and asking a lot of questions. So those are things I would have ready. If you have any sketches, I would certainly certainly bring them to the meeting. But that's really about it to get started initially, anyways.
And then, so like, if you file the provisional patent, but the product is still like evergreen, it's still not at its final point, how does that work? Like, you just submit changes to the existing provisional patent, or you have to put in a new patent? Or I guess I don't understand that part.
Yeah, that's a good question. So, you can do either, and it often depends on, how the scope of the changes that you have. So if you have minor changes, or not significant changes, they're just optimizations over what you already submitted, then we will typically just incorporate those changes when we convert the provisional into a non-provisional application. But if there are major changes that fall outside of the scope of the original filing, then sometimes we recommend filing a new application incorporating that new material. But usually that new material is not a whole application in and of itself. Usually we are able to add a couple of pages of description to the old one and then submit that as a new provisional. And then you have two provisionals that are co-pending at the same time. And then when you turn the provisionals into non-provisional, you claim priority to both of those provisionals. Does that make sense?
Yes.
Okay. Good question. And then Valerie, you had mentioned design patents. There is no such thing as a provisional for a design patent. So, if you're going to file a design patent, you had to file it essentially as a non-provisional.
So what is the difference between like the design and the utility patent?
Yeah. So the utility patent protects the way something works, and the design patent protects the way something looks. So you have to figure out, what is the most important part of your invention? Is it the way that it looks, like the shape of the Coca-Cola bottle or the shape of the iPhone? Or is it the way that it works, right? Is it the way that the semiconductor inside the iPhone, that's the way it works? Or, for example, the Coca-Cola um, can, right? We have a tab to open the can and release carbonation. If it's the way that the mechanism, the pull tab works, then you would file a utility application. But if it's, if you want to protect the way that it looks, then you would file a design patent.
I see. Thank you.
Mm-hmm. Other questions?
In your experience working with business owners, small business owners trying to get patents, do they usually like seek a patent before going to market, or do most of the people that you work with already have like marketable business and are trying to get that patent after being in the market?
Good question. I think it's about 50-50. So I think it really depends on the risk tolerance of the company or the founder or the inventor. I would say about half of my clients are filing before they get to market. And then the other half are filing after they go to market. And I think it really just depends on the risk tolerance, like I said, but also, the amount of money that they're going to have to spend to get to market, right? If it's, if it's not going to cost you a lot of money to get to market, then you might as well kind of take a shot at the marketplace and figure out if this product has any legs, right? If it's going to do well. And then if it does well, then you can go and patent it after the fact. But if it's going to take you $1 million and 3 or 4 years of development time to get it to market, then often it's a good idea to first file, get the patent protection before you spend $1 million.
Thank you.
Mhm.
I'm curious to know, Samar, what are
Mhm.
like I know you work in California, Silicon Valley, so that must have been pretty competitive and kind of if you were had a software or something that was going to market, you probably want to protect it before having meetings and everything. But I'm wondering, in San Antonio, what have you seen in the sense of like competitiveness, and what people usually come to you with, and what do you think are some that are kind of more saturated in our market?
That's a good question. I would say that most of my clients are competing not just in San Antonio anymore, right? They're just really competing on a national level because of the internet and because of the way that most products are sold nowadays. So, for patents, and trademarks as well, these rights are federal in nature, so they extend throughout the country and not just the state or the city. So if you have a product that you're going to sell online and you're going to sell to lots of different people outside of San Antonio, I think federal rights make a lot more sense, and your level of competition is really the whole country or the whole world. So it wouldn't make any difference from that perspective. Now, if you have a more local based business, obviously the competition is going to be less, so you can wait on some of these legal costs. But it depends. Even with a trademark and state-based trademark, you could have I had a client who was a dentist, right? And they had a name that they were operating under, and somebody else, just down the street from them, started a dental company with the same name. And they were like, what can we do to stop this? We're losing customers, or our customers are getting confused. And, without having filed even local trademarks, you don't have a lot of recourse at that point. So, I would say that you can take your shot at not having a lot of protection early on, but as soon as you have the money to do so, you should start formalizing this thing before somebody infringes on your rights. So that's the cost benefit analysis is something that you should be asking yourself all the time as a business owner. When does it make sense for you to start having formal IP protection around some of this stuff? Like that dental office was making, it had lots of money, right? They were in business for 8 or 9 years, something like that, and they were profitable for all of those years. And they very well could have just taken 10 minutes to call a trademark attorney and file a trademark on their name, but they just didn't do it. I think it just slipped for them, and and that was a mistake, right? That's going to cost them a lot of money to fix now. So I would say the earlier that you're able to do some of these things, the better. I think of intellectual property rights as like an insurance policy, right? You never know. If things go well, you'll never need to use your IP rights. And in most cases, you're not going to use your IP rights. But in the 5% of cases where this becomes an issue, it becomes a very expensive issue to fix, right? And potentially catastrophic to the business. So, you can operate your business without an insurance, but I wouldn't do it for very long, right?
Yeah, I think that makes a lot of sense. A lot of times, maybe you look to save some money, and mainly when you're starting out, but that might have something to do. Like it depends, like you said, on the business and the market, and how much risk you want to start with. And if you already have some money set aside for it, then you should probably look into it, or even consider as you start as part of the cost of starting out a business.
Yeah, and there's not going to be one good answer that works for everybody here. If I have some clients who like tomorrow, if they wake up and change the name of their business, they will lose zero revenue, right? Because like people are doing business with that person, and they almost don't care what the name of the business is. So if you fall under that category, then trademark rights are not that important to you, and not worth investing money in, especially in the early goings when money's tight. But if you're relying on your name and you become well known in your community with a particular name, then yeah, trademark rights become very, very important to you. So you have to think about all these things, and no answer that I can give you today is going to be a silver bullet that works for everyone. But you really have to think about your circumstances and what makes sense to you.
So, Samar, I have another question. I hope Daniela, if you were done, if not, I'll continue. But
Yep.
my question was, would you suggest, like, what about if I just submit provisional patents and then when it's getting close to a year, go to an attorney and say, okay, can you help create the non-provisional patent based on these provisional patents that I have now that the product is complete and this is how it looks?
Yeah, and I have a lot of clients who do that. So I think it makes sense, at least in the early goings, to save cost on attorney's fees um, with that provisional. With provisionals, I think you can do them on your own for the most part. There are, 4 or 5 things that you really have to worry about with regards to a provisional, and I'm happy to walk you through some of those things. But yeah, I have lots of clients who write their own provisionals, and then when it's time to convert them into non-provisionals, they reach out to me, and we can do a lot more formal work at that point to get the protection done in the right way.
Do we have enough time, or do you mind going through those 5 things? I don't know.
Yeah, and maybe we can set up a call. It's just those 5 things are not universal, unfortunately, and a lot of it just depends on what your product is. But I would encourage you to write up your description in both broad and narrow terms. And what I sometimes see is that clients write in too generic terms, too broadly, to meet what is called the enablement requirement, to enable somebody else to make the invention based on your description. And on other times, the clients go too far in the other direction and make the description too specific and too narrow. And then you don't have protection over the broader concept. So you want to avoid both of those traps. You want to write, think about it as writing just 3 different applications, right? Write the first application in broad generic terms, write the second application in intermediate terms or scope, and then write the third application in very specific terms. And that way you have both broad, narrow, and intermediate coverage on your application. So that would be the number one thing. And the other times what I see is clients don't do a very good job of including drawings and figures in their application. Especially if you're not trained as a patent writer, it's easy to make some mistakes, but drawings, it's harder to make mistakes with. Like a picture is worth 1,000 words, they say, right? So the more pictures and drawings and sketches or schematics that you can include in your application, that would be well worth your time in doing so. So those are a couple of things. There are a few more that may or may not be applicable to you here.
That's very helpful. Thank you.
Mm-hmm. Any other questions?
I have a question. As far as trade secrets go and like protecting a procedure, how specific does it have to be?
Yeah, and there's no general rule of thumb on that one as well. I think you know, yeah, it really depends on what it is. Is it a recipe? Is that what it is?
Well, to be honest, I think my recipes like are more or less safe for what I want to do because I don't see even I watch like a ton of other cooking shows and stuff, and I don't see a lot of people applying the same kind of recipes as far as cookies go. But like I said, what I want to do is more protect the idea or the procedure of kind of the on the spot, customize your own, ready in less than 10 minutes, fresh cookies.
I see. So it's a procedure for doing that.
Right.
Yeah, I mean, if you have a procedure and if you need to put the procedure down on paper, I would just use as much detail as you need to direct your employees on how to do it, and then I would have put it in a separate binder and label it trade secret in prominent letters, and make sure that the folder is under a lock and key, and that it doesn't have, people don't have access to it, right? So you need to take those safeguards and those procedures to make sure it's secure and doesn't just walk away. And then, with your employees or contractors, I would have it in their agreement that they can't disclose anything that's in that binder or that's labeled trade secret. And if they do, there'd be, severe legal consequences for it. So I would do those things to protect a trade secret. I'll give you an example of how people run into trouble with this stuff. So we had a client who was a medical device client, and they had these machines called flow cytometers, and the way they worked is they would detect cancer cells within your regular blood cells. So you run a sample of blood through the machine, and it would detect how many cancer cells were in that sample out of X amount of blood cells. And what my client had done was also come up with a procedure for processing these samples in a way that allowed the scientists to process 4 or 5 samples at the same time without making mistakes. So they had a very specific procedure for doing this, and then there was a defendant in that case who stole that procedure, and we filed a lawsuit saying that, hey, you stole our trade secrets. And we went to court. We were in front of a jury, and the defendant's arguments was this: that, hey, this was not a trade secret because, look, these binders, the procedure binders, were sitting on the table all the time while the scientists were doing their analysis. And from every summer they had a tour group from from Texas A&M come through, right? The PhD students or master's candidate students who would tour the lab. And they were like, well, it was not under a lock and key because, look, the binders were on the table, and there were university students walking through it from time to time. So how can that be a trade secret? And ultimately we won on that issue, but those are the things that you'll run into, right? People are going to say, hey, this is not a trade secret because it's not under a lock and key. So you really have to make efforts to preserve that secret. Does that make sense?
Yeah.
Okay.
Well, I think,
And it looks like we may be running out of time here, and I have another call that's coming up here.
yeah, I think that's all the time we have. So I thank you, Samar. I'm sorry that we ran 7 minutes after, but thank you for this, and we'll share with you the recording. If you guys have any more questions, we'll share them with Samar or share their contact information.
Okay. Yeah. Thank you, guys. I really appreciate all the questions.
Yeah, no problem. Have a great day. Thank you, guys.
Yep. Bye-bye.
Thank you.